Hi, hello. Welcome everyone to this IT governance webinar. We are going to go through today regarding the first step toward GDPR compliance. So I'm Eugenie Lorians. I'm a GDPR consultant and will be your speaker for the day. So as a GDPR consultant, I have been working for a wide range of different organizations, and we'll be here to help you to understand how in practice we could implement this GDPR. I'll give you some guidelines around it. So IT governance, as you must be aware, has been founded 10 years ago. IT governance, it's the main source. It will be the supply, mainly everything related to cybersecurity, risk management, compliance generally. He is also the market leader for ISO 27001. It has a control framework and in data protection related to this general data protection regulation. Regarding what we are going to go through today, our discussion will be related to give you, first of all, an overview about the material and territorial scope of this GDPR, when you should implement this GDPR. And also, we are going to review the main principle of this GDPR. As you are aware, under the GDPR, we have 6 data protection principles, while under the Data Protection Act, we had 8 data protection principles. It doesn't mean that 2 has been removed. It's just that the rights of the data subject and the transfer of data are now part of a proper chapter. We are going to review then the breach notification rules, so what might be the obligation for controller and processor in case of a personal data breach. And we will be able to discuss, to go through how to communicate it to the data subject. Then we are going to review the data subject rights. So as you are aware, there are some new rights that have been added under this GDPR, including the right to data portability and the right to be forgotten. We are going to review now the different lawful bases for processing data, including consent, and we'll be reviewing also the changes related to consent given by employees. In the next section, we will be reviewing the processor liability, so its role and obligation according to the GDPR. Then we are going to go through the role of the DPO, and we'll be discussing in which occasion the appointment of a DPO is mandatory, or on which occasion could you have potentially a DPO as a service. We are going to review then the transfer of personal data. So it will depend if it's a transfer within the EEA countries or if it's outside the EEA. In that situation, you will have to implement some guarantees or some mechanisms in order to transfer data. To conclude, we will be reviewing the different supervisory authority and the regulator. Now, let's go through first about the European legislation, or the nature of European law. So as you must be aware, in the EU law, we have 2 types of legislations. We have the directive and the regulation. The directive has what we call an indirect effect. So that means that to be implemented within your own law, within a member of state, the member of state will have to implement his own law. For example, we had this European Data Protection Regulation Directive that have been implemented in 1995, and to give effect to this directive, the UK has to implement its own law, the Data Protection Act in 1998. At the opposite, we have the regulation. The regulation has what we call a direct effect. So it will be implemented directly into each member of state without the need to implement any local legislation. This is the reason why it has been decided to for this GDPR to be a regulation, is to make sure that now we just have one consistency legislation across the EU. As you must be aware, under before this GDPR, we had a mandatory DPO in Germany, while it was optional depending on scenarios for the UK. So the main idea why it has been decided to the GDPR to be a regulation, it's for consistency reason, to make sure that now all across the EU, the country are following the same legislation. So it's really to make sure that there is an harmonized level of data protection legislation across the EU. So now, in this slide, if I have to summarize GDPR, here we are. Let me go through it. We have the data subject. The data subject is any living individual. The data subject will give his personal data. Let's say he will fill a form on a website. He will give his personal data to the data controller. The data controller will be the one determining the mean and purpose for processing personal data. Then the data controller, in most of the situation, most of the occasion, will outsource the process of processing and will outsource to a data processor. Generally, mainly, the link between the data processor and data controller will be a contractual obligation. The data controller will generally recommend to the data processor to have a level of security, making sure that the personal data he is outsourcing to the data processor has a sufficient level of security. It could potentially recommend to be ISO 27001 compliant. It could request the previous data protection impact assessments that have been previously conducted. It could suggest to get the previous audit on the security controls that the processor may have already implemented or conducted in the past. The data controller might send personal data outside the EU law to third countries. In that situation, the data controller will have to make sure to have appropriate mechanisms. The appropriate mechanisms, we have some mechanisms that have been approved by the GDPR. We'll be reviewing it later on. The data controller might also be using the service of a third party. The relationship between controller and third party is well defined, need to be clearly defined according to the GDPR. The information, so then we have the supervisory authority. The supervisory authority, as you are aware, in each EU country we have a different supervisory authority. In the UK we have the ICO, in France we have the CNIL. The purpose of the role of the supervisory authority, it could assess or enforce the GDPR compliance. Could make sure, it could investigate your compliance with the GDPR. It could enter your building, review your equipment, your softwares, interview employees. It could also, as you are aware, levy some fines. Above the supervisory authority, we have this European Data Protection Board. Within the European Data Protection Board sits one representative of each member of state. Each member of state will have one representative who will sit on the European Data Protection Board. The purpose of the European Data Protection Board is to make sure that this EU GDPR regulation remain harmonized all across the EU. Now, let's move now about in which occasion should we implement this GDPR. What is the material and the territorial scope? First of all, let's define what is a data subject. A data subject is, according to the GDPR, it's a natural person. So that means a living individual. It does mean that it does not include deceased individual. So as any natural person, the data subject will have rights associated to the protection of its personal data. It will have some rights related to the protection of the processing of its personal data. Any EU individuals may have his personal data moved without any restriction across the EU. There is, as you understood, an unrestricted movement of personal data within the EU. Now, two things regarding the objective of this GDPR. The first one, as you understood, is to make sure that this European data protection regulation will remain harmonized all across the EU. The second main objective is for the data controller to facilitate the data subject, to facilitate the exercise of the data subject rights. Now, regarding the material scope, the GDPR mentions that the GDPR will apply when the personal data are processed wholly or partly by automatic means, that means by computer and application form. The second material scope is when the personal data is part of a filing system. It does mean that it does include hard copies of personal data. It does make sense. Imagine now all the clinical records in hospital, or all the client records in a law firm. Everyone, all organizations now need to comply with the regulation. Also, out of the scope, as you may have understood, out of the scope will be, for example, the personal data related to purely personal activities, or could be personal data related to crime prevention. In that situation, the GDPR will not apply. It does make sense. You imagine a police officer tracking a gunman, he might not request the location of the gunman in order to locate himself. So now, regarding the material, the territorial scope now. The GDPR will apply to controller and processor that have their main establishment within the EU. First option. Then the GDPR will also apply when the processing activities is related to goods or services targeting EU individuals. We are not taking into consideration if payments have been taken. It's more about the processing activities related to goods or services targeting EU individuals. Now, the third territorial scope, it's about the processing activities related to the monitoring of data subject behavior. Now, Article 83 of the GDPR will be related to the general condition for imposing administrative fine. What's happened is that generally when the supervisory authority will impose administrative fine, it will take into consideration in each case that the fine is effective, proportionate, and dissuasive. How to define those terms? Those terms have been defined by, they will take into consideration, in order to meet those criteria, for example, the nature, the gravity, and the duration of the infringement, but also maybe the character and negligence, intentional of the character of the infringement. But mainly, when imposing an administrative fine, the supervisory authority will take into consideration if the controller and processor have implemented a sufficient level of technical organizational measures. One important element when they will be considered, when the supervisory authority will be considering the amount of the fine, they will take also into consideration any actions taken by controller and processor in order to mitigate the damage suffered by data subject. What does that mean? They will take into consideration if, for example, the controller and processor have put a sufficient level of encryption, some access control, this kind of technical controls. Now, as you are aware, the fine that can be imposed by the supervisory authority could be up to 2 to 4% of your annual turnover. It will depend on the infringement. Up to 2% of the annual turnover might be mainly related to the security of the data, about the level of security that you have implemented to make sure that personal data are secured, are kept secured. Now, you can be fined up to 4% of your annual turnover if, for example, you haven't implemented within your organization the data protection principles, or if you haven't facilitated the exercise of the data subject rights, might be the situation where you can be fined up to 4%. Article 33, it's about the personal data breach. GDPR will be only related to data breach, but only related to personal data. You will tell me, what is a personal data breach? A personal data breach means, for example, any breach of security leading to the accidental, unlawfully alteration, unauthorized disclosure, access to personal data. What will happen next is that when you will have, if the data processor notify or is aware of a personal data breach, it will have to notify the data controller. In your processor contract, you will have to mention it. You will have to make sure that it's mentioned that the processor will have to notify the data controller without undue delay as soon as it becomes aware of this data breach. Don't forget that as a data controller, you will be accountable for this personal data breach. So make sure that in the processor contract, this is mentioned. In the processor contract, again, you want to mention that every data breaches will have to be reported to the data controller. Now, regarding the obligation to the data controller, yes, so under the GDPR, the data controller has the obligation to notify to the supervisory authority any personal data breach. But wait, fortunately for everyone, it's not every personal data breach. It's mainly the ones that are considered that might result in a risk to the right and freedom of natural persons, of data subjects. This is again a board decision who will decide if it's a risk to the rights and freedom of natural persons. But if you are unsure if you should notify or not this data breach, just discuss, communicate with the supervisory authority. Now, you should be aware that you will have to notify this personal data breach without undue delay. It has been defined as no later than 72 hours. So don't forget, there is no holidays for personal data breach. If it's happened on a Monday, on a Sunday at 4 p.m., this is where the clock will begin. Don't forget, when you will notify to the supervisory authority this data breach, you have to describe the nature of the breach, but also any action taken to mitigate the risk. this is some information about when exactly what has been the step in order to this GDPR to came into force. So yes, on the 8th April of 2016, there was this Council of the European Union that adopted this GDPR. Okay, and on the 24th of May 2016, as you are aware, the regulation entered into force. And as you are aware, on the 25th of May 2018, the GDPR came into force, is now implemented. So that means that the European Data Protection Directive stopped to have effect since the regulation took over. Now let's go through the rights of the data subject. As we mentioned earlier, the controller have one obligation under the GDPR. The controller have to facilitate the exercise of the data subject rights. So he will have to communicate to the data subject how to exercise his rights. But first of all, the controller have an obligation to be transparent with the data subject. He has to communicate, for example, for how long he is keeping his data, which type of personal data he's collecting from the data subject. He has to advise there is any transfer of data if he's outsourcing his personal data to a data processor. He has to be transparent. The controller has to be transparent with the data subject. And you will tell me, by which way, how to communicate it to the data subject. One way to communicate it to the data subject is via a privacy policy or privacy notice. Again, the GDPR advises that now the privacy notice, privacy policy need to be friendly. What does that mean, friendly? It needs to be easy to understand, clear, plain language need to be used, okay? It needs to be concise, intelligible by anyone. No need to be a lawyer necessary to understand. It should be understandable by everyone. So now, the data subject, so via this privacy policy, will be aware of the different rights. Will be aware of his different rights, but also how to exercise his rights. How to exercise his right to access his personal data, how to rectify his data, how to exercise his right to be forgotten, to restrict the processing of his data, to object. There is an absolute right to object for the processing of his personal data for direct marketing, for example. Now, it should be also mentioned how to exercise his right to data portability. Obviously, to be able to facilitate these rights, it's mainly when there is consent of the data subject. And when it's also, so only by this, the exercise of the data portability can only be by automatic means. Also, in this privacy policy, you also want to mention the lawful basis on which you are collecting data from data subject. But you also want to mention how to withdraw, how the data subject can withdraw his consent at any time. And also the right to lodge a complaint. You should be aware how to exercise these rights. Article 5 is related to the principles, the data protection principles. As we mentioned at the beginning, under the GDPR, we have 6 data protection principles. While under the Data Protection Act, we had 8 data protection principles. It doesn't mean that 2 has been removed. It just means that rights of the data subject and now the transfer of personal data are now part of a proper chapter. Now, let's go through the principles. So principle 1, it's related to process lawfully, fairly, in a transparent manner. Yeah, you need to communicate transparently to the data subject how you are processing with the data subject data, personal data. You want to advise if you are transferring his data to a data processor. You want to mention for how long you are keeping the data. If there is any transfer outside the EA to the third country, for example. You also want to mention, so yeah, then the principle two, it's about the collection of the data need to be specified, explicit, and legitimate purposes. Yeah, you don't want the data subject to tick in for a group of purposes. You want them to tick in a box for each purposes. Principle three, it's about adequate, relevant, and limited to what is necessary. Yeah, you don't want to collect data just in case. You want to collect data, just what is needed for the purpose of your activity. Accurate where necessary, kept up to date. You are accountable to make sure that the data you are collecting are up to date. But then you will tell me, well, might be a tough work. You might want here to mention within your privacy policy, maybe a way to the data subject to modify themselves their data. Could be to log in into their personal web pages or by emailing HR at privacy team. You decide. Retain only for as long as necessary. Each personal data should be linked to a retention period. This is about the retention period for each personal data. You have to communicate it to your company and to each department for how long they should keep each personal data, each document. For example, CVs of unsuccessful candidates should be kept for no longer than 6 months. So you have to also to go through the legal requirements for each documentation, and also on the top of it, you can decide what might be the best practice according to your sector activity. Principle 6, it's about making sure that the data, the personal data that you are collecting are kept with a sufficient level of security. Okay, it's about maintaining the security of your data. One element that I would like to add is that under the GDPR, the ICO, as mentioned under the GDPR, so the data controller will be accountable to make sure that all the 6 principles are implemented within the organization. Yes, so the data controller will have to make sure that all the data protection principles are implemented. Okay, and one way to be transparent about it, it will be to mention it in your privacy policy. So definitely it will be a change to the culture of your organization. You will have to review your process and to make sure you have integrated into your IT system the data protection. So this is the element about, this is what we mean the data protection by design and by default. Yes, as up to now, you need to integrate into your IT system level of data protection. Again, how to apply or how to comply with this principle of accountability. You might want, first of all, you want to make sure that you have meet this principle by a board accountability. You should have now within your organization corporate risk register. So corporate risk register that the GDPR should also include the privacy risk, the risk related to the exercise of the data subject rights, and all about the risk related to the data subject or data protection. You want also to nominate a responsible director that will have access to the board, so we'll be able to discuss and to take board decision. Regarding clear roles and responsibilities, you should appoint in some scenario a data protection officer. It will depend on 3 scenarios. It will be mandatory in 3 scenarios according to Article 37 of the GDPR. Now, you also want to have a level of privacy compliance framework. So yes, you should have some control framework, some standard of control framework, as for example, ISO 27001, which is an international standard that ensures a certain level of security. Or you have also some alternative as Cyber Essential, which is a minimum security standard that you might want to have in place. You want to also record all your processing activities. you might want to look at the ICO, which has released some guidelines about how to record your processing activities. You also want to make sure that you have implemented the data protection by design and by default. One way it may be to begin or to conduct a data flow audit and to conduct a data protection impact assessment if you haven't done it yet. As you are aware, under the GDPR, it will depend on different scenarios that you should conduct a data protection impact assessment, including in particular when you are processing a high level of sensitive information. Regarding the lawfulness, as you are aware, Article 6 is related to all the lawful bases to process personal data. The main one, it will be the data subject who will give his consent for specific purposes. So you don't want the data subject to tick in a box for a group of purposes, for example, marketing sales. You want him to tick in a box for just a specific purposes. Under the GDPR, the consent has been defined as a clear affirmative action. Now, under the GDPR, the data controller will be accountable to collect the consent from the data subject. But fortunately for everyone, there are some alternatives to consent. For lawful basis, you can also use, it could be the alternative lawful basis could be for vital interest, legal obligation, contractual obligation, or legitimate interest. Again, the controller and processor need to be clearly distinct. They have different obligations. And in your processor contract, you want to review the obligation of the processor according to Article 28 of the GDPR. As soon as the processor is acting on behalf of the controller, he will be acting within the scope of the contract. But if he's acting outside the scope of the contract, he will be engaging his own liability. As we mentioned earlier, the consent must be a clear and affirmative action. Yes, the data controller now must be able to demonstrate that the consent has been given by the data subject. Yes, before that, under the Data Protection Act, it was the data subject who has to demonstrate that he given consent. Now the situation has changed. When asking consent, when collecting consent, the consent needs to be clearly intelligible, easily accessible, otherwise non-binding. So when a data subject will consent, the consent should be the mirror of the withdrawal. So it should be as easy to tick in to consent or to withdraw. As you must be aware, the consent of employee under the GDPR has been qualified as invalid because now the employer can't rely on the consent of the employees as a valid consent when they want to process with their sensitive information or special categories of personal data. So we need to ask consent in a further agreement. Now, as you are aware, there are some special conditions for the child under the age of 16. So that means that when a child is under the age of 16, when it's related to information society services, the data controller will have to collect parental authorization in order to process the information of a child. Now, under the GDPR, now related under the GDPR, when you are processing special categories of personal data, you have to be aware that it's prohibited to process the special categories of personal data of data subjects. What are the special categories of data? It includes race, ethnicity, political beliefs, health information, biometrics. Fortunately, in order to process the special categories of data, there are some exceptions, including explicit consent from the data subject, vital interest, or if the information has been made public. Now, when you are under Article 12 of the GDPR, now, as you are aware, the data controller need to communicate transparently in a concise way to the data subject about how his personal data are being processed, which type of personal data is being collected, for how long, if there is any transfer outside the EU. You have to communicate to the data subject how to make, for example, a subject access request, how to lodge a complaint. As you are aware, one right of the data subject is also to make a subject access request. Subject access request can be made by any data subject as soon as they have the right to do so. The main idea under the GDPR is that you have 1 month, the data controller has 1 month to answer a subject access request. Under the Data Protection Act, the data controller had 40 days. So you want to make sure to have a system in place, a training to make sure that you are monitoring the 1 month to be able to answer this type of request on time. You want maybe to have someone in charge within your organization of this subject access request who has been well trained and who is aware what is the personal data and to who to contact to, who will be the personal data owner in order to answer as soon as possible, as quickly as possible, a subject access request. Now, under Article 14, there are some situations where personal data might be collecting not directly by the data controller, but indirectly by the data controller. So in that situation, you want to mention the data controller that did not collect all the personal data directly from the data subject will have to mention, to include in this privacy policy, where does he got the contact from? Where does he got the personal data of the data subject from? If he got the personal data from company A, company B will have to advise in the privacy policy where he got the contact from, so from the company A. Again, in this privacy policy, you have quite a few information that you need to advise to or to communicate to the data subject. It does include all its rights, but also how to exercise its rights. Now, Article 25 of the GDPR, it's about the data protection by design. Yes, so from now, the data controller will have to integrate into its IT software a certain level of data protection. Data controller and processors that are not established in the EU will have to appoint a representative. So what will be the representative? The representative will be just a point of contact. He will be the one that you will have designed in writing in your privacy notice. So data subject will be aware to know who is the representative. You want also to conduct some data protection impact assessment. In some scenario, you will see on Article 35, the data protection impact assessment will have to be conducted. It includes a scenario where you have you are implementing some new technologies, or if you are processing some personal data that are likely to result in a high risk to the data subject. Now, one way to begin this data protection compliance or to comply with this GDPR will be to begin via a data audit. You might want to conduct a first data inventory to maybe already discuss about to identify the data you have within your organization and to decide if you still need all those data or if you could potentially minimize the volume of data that you are collecting from data subject. Don't forget that you are accountable for the data of the data subject from the first point of collection to the moment where you are deleting the data. Also, don't forget that it's always cost effective to secure data. So the main idea, it will be to maybe identify all the personal data you are collecting from data subject, to identify which one do you maybe not require anymore for the purpose of your activity. Article 32, it's about the security of personal data. It does refer to the Principle 6 of GDPR that you will remember from the beginning. The main idea here is that we want the data controller has to make sure that he's implemented a certain level of security around the data. Okay, it's just to make sure that it avoids any personal data breach. It's to make sure that the data controller is minimizing the risk on its personal data. Okay, so we want to make sure the data controller have to make sure to implement a certain level of technical and organizational measures. By technical measures, we mean encryption, we mean access controls, for example. By organizational measures, we mean a certain level of policies, procedures, training policies, for example. But it's not only about having policies. Be aware that policies need also to be signed off and implemented within your organization. And ITG will definitely recommend to provide some training around the policy to make sure it's properly implemented. Don't forget that mainly the cyber incident or the personal data breach came from a lack of training. So one way to secure your data, as we mentioned, might be to implement a certain level of controls appropriate to the risk. So it could be pseudonymization, encryption of your data. So the main idea is to ensure the CIA of the data. What is CIA? What does that mean? Confidentiality, it means some access control, integrity, making sure that your data are up to date, availability, it's related to business continuity, making sure that you have an option if you have any problem, you have a business continuity plan to access your data. Now, how to make sure that your data, your personal data, are securely saved? One way is to maybe process regularly with some penetration testing on your softwares, on your website. Also, to evaluate the effectiveness of security measures in place. Don't forget that the security measures that you take need to comply with this concept of data protection by design. One certification that demonstrates the intent to secure your data and that are an international standard, it's ISO 27001. A lot of clients have been asked to comply with ISO 27001 because it ensures a certain level of security around the data. Now, the privacy compliance framework, it's a link between the privacy policies, the policies procedure, and the governance with compliance. Article 37 now, it's about the data protection officer. So there are some requirements, there are some scenarios where you should appoint a DPO. So it's mainly when it's when you are processing a high volume of personal data, when you are monitoring on a large scale data subject behaviors, or when the processing of activities is carried out by public bodies. The DPO has a role protected. It should have direct access to the senior management. It doesn't need to be a lawyer, but it does require that the DPO has practical knowledge about legislation, about data protection, and about mainly the GDPR. So in some circumstances, so the DPO could be a full-time employee, a temporary part-time employee, but can also be an external DPO. You may have heard about this concept of DPO as a service. So most of your staff, we definitely recommend that most of your staff that are dealing with personal data should have a certain level of training to understand exactly the requirements under GDPR, how they should process personal data, and also around the security they should bring around the data. So some staff awareness are definitely recommended across the organization. Now, there are some certifications that are appropriate to having a sufficient level of administrative measures. How to demonstrate this? How to demonstrate that you are GDPR compliant? It could be, for example, to implement within your organization some international standard control framework like ISO 27001 or has a national management standard, the British standard 112. But there are also some alternatives that are also a good practice, which is the first one is the Cyber Essential or Cyber Essential Plus if you are dealing with government. Article 44, it's about the international transfer. So you might transfer some personal data either within the EU. In that situation, you do not, as you are aware, you can send unrestricted, you can, the transfer of personal data can be freely done across the EEA country on the basis of adequacy decision. Across the EEA countries, personal data can be transferred on the basis of adequacy decisions. But now, if you are transferring, if the data control is transferring personal data to third countries, it will have to put in place some alternative mechanisms. The first one is you might be, the EU Commission might consider that some third countries could rely on adequacy decision to transfer personal data. If it is the case, the country will be mentioned in the journal of the EU Commission on the EU Commission website. The second alternative is the standard contractual clauses. If you are two different organizations and want to transfer data, you might want to include in your contract standard contractual clauses. The model of those clauses will be found on the EU Commission website and will need to be approved by the EU Commission. The third alternative might be the binding corporate rules. The binding corporate rules, it's within a group. You might want to put in place this mechanism in order to transfer personal data all across the group. But wait, you have to be aware that to get the binding corporate rules approved by your leader supervisor authority, it might take some time, might take up to 2 years. But now you are aware about the different options to transfer personal data. Now, if you are transferring data, if the data controller wants to transfer data to US, there is in July 2016 has been approved and implemented the EU-US Privacy Shield. It's a certificate, it's a safe assessment certificate. You can check on their website. Before getting approved this EU-US Privacy Shield, there was in place the Safe Harbor Agreement. It has been considered by the EU as having a lack of data retention principle and has been considered as not meeting EU adequacy standards. But now, for the transfer with the US, as up to now, we can still rely on the EU-US Privacy Shield unless otherwise said. Now, regarding the supervisory authority, as we mentioned from the beginning, there are one supervisory authority in each member of states. Regarding the role of the supervisory authority, it can provide guidelines, release guidelines that will help you to implement this GDPR. They will help you to monitor and they will enforce this GDPR, enforce the data protection compliance. But they can also, as you are aware, they can levy some fine. If you are not meeting the requirements under GDPR, the supervisory authority can levy some fine. Now, regarding the powers, so they can definitely now, under the GDPR, it has been approved that the ICO or any supervisory authority could investigate your IT software, could enter your building, could interview employees. Now, there is one scenario where you might want, if you are, for example, within a group, if your company is a big group and you are implemented, you have a subsidiary in France, in UK, in Spain, you want to decide, you as a board decision, you might want to decide who will be your lead supervisory authority. Now, we have another regulator. You will remember from the slide at the beginning. It's about this European Data Protection Board. On this board sits one representative of each member of states. The main purpose of this board is to make sure that this GDPR legislation remain harmonized all across the EU. The European Data Protection Board will have the final decision in case of any conflict. They will also making sure to ensure this cooperation, this consistency across the different supervisory authorities. You should also, if you wanted to read more about the board view on the data protection level, you might want to read through the board meeting notes that are available on the website. So now, let's go through the final step to GDPR compliance. If you have the different step to be GDPR compliant, you need to establish a governance framework. This is to help you to begin your action plan. You want to review and to establish a governance framework to appoint and train a DPO, or a DPO has a service. You want to conduct a data inventory to identify your processor, the data that you hold. You want to conduct data flow audits, some compliant gap analysis. You also want to conduct a data protection impact assessment, and maybe later on, and then the next steps will be to remediate. So to implement properly this regulation, how in practice you will implement it, you will use the service of remediation. You want also to establish a data breach response process, and you will want to keep and to monitor the compliance, making sure you have a continual level of compliance with this regulation, and making sure that you are continually improving your level of compliance. So now, to finish, I will just review with you the different products and services that we offer at ITG. We have some self-help materials, a pocket guide, implementation manual, documentation toolkit, and compliance gap assessment tool that will help you in order to begin your GDPR compliance project. We're also training one-day training foundation courses or practitioner courses, online or on-site, I mean classroom, or online or distance learning. We also provide some one-day DPIA workshop. If you have any questions, I'm available to answer any of your questions that you may ask. You may find a box, a chat box, or question box where you could ask questions. I may have answered all the questions. So don't forget that if you are beginning this action plan, your GDPR action plan, do not forget to maybe prioritize first to making sure that you have updating your privacy policies, because don't forget that it's the first way it's the first communication to the data subject. So regarding the administrative fine, you have to be aware that depending on the article you will be not complying with, you can be fined up to 2 to 4% of your annual turnover. So if, for example, you can be fined up to 2% of your annual turnover if you are not meeting the articles related to the security of your data, if you haven't notified to the supervisory authority a data breach, and you can be fined at the opposite 4% of your annual turnover if you are not implementing a sufficient level or if you have not implemented the data protection principle within your organization. Don't forget that we have 6 data protection principles under the GDPR that a data controller will be accountable for. So now, if you are so you have to be aware that a data processor will be someone that will act on behalf of the data controller instruction. So that means that if you are using, for example, the service of an IT company, it might be you might have a contract with this processor as a data controller. So you might be outsourcing your IT systems. In that situation, the IT company might be a processor. In that situation, you want to make sure that your processor contract with this IT company comply with the Article 28 of the GDPR. All the activities that will be delivering these IT companies will need to be listed within your contract. Do not forget or keep in mind that the data processor will be engaging his own liability if he is acting outside the scope of the contract signed with the data controller. Now, you have also to understand that under the GDPR, controller and processor are by principle jointly liable. Okay, but one way to mitigate the fine will be to be clear in the processor contract about the liability of the data processor. So one way to comply with that will be to make sure that in the processor contract, you mention all the activities that the data processor will be delivering. That way, as a data processor, you can minimize your liability because you will have acting on behalf of the data controller. I hope this GDPR webinar has helped everyone, and I hope it has been helpful. And do not hesitate if you have a last question you want to ask. Otherwise, it was a pleasure to discuss with you. Thank you for your time, and I hope to speak to you soon. You might find a handbook on the site, a PDF handbook, if you wish to go back to the slides.